Welcome to Sakshi TV Special Immigration Show with attorney Mr. Parvathaneni from law firm of Parvathaneni and Brown. Please note that Sakshi TV now has 4 shows every week. On Tuesdays with attorney Mr. Srinivas, on Wednesdays with attorney Ms. Prashanti Reddy, on Thursdays with attorney Mr. Parvathaneni, and on Fridays with attorney Balu Inindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 866-725-7441. Before we get on to the show, please note that the information provided on the show is not legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information. Now, Mr. Chand needs no introduction, but if you need any specific legal advice, you can log on to spblawfirm.com site. Now, the spblawfirm.com site has a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. They also provide if you need any legal advices, you can definitely log on to that site. Now, before we get onto this topic, the viewers can call on the numbers on the screen if you have any questions related to immigration show. So now, Mr. Chand Garu, welcome back to our show. Can you firstly tell, are there any recent immigration updates that the viewers must know this week?
Thank you, Shivani. As an overview of the major immigration changes that have happened so far this year, there are a lot of positive things that happened this year in general. The biggest thing is COVID pandemic started settling down. People started getting back into the offices. And what that means is the USCIS, the immigration services, they started becoming more efficient. Over the COVID pandemic time, a lot of cases got slowed down and things were very, very slow. And this year, we're starting to see very efficient processing of pretty much every case we are filing with USCIS. And that's a very major change. And they also introduced a lot of new changes this year. And some of the noteworthy changes are extension of automatic work authorization for anybody with EAD card EAD card that is about to expire or has expired. It used to be 180-day automatic extension after EAD expiry. That has been now extended to 540 days. So that's a very major change that happened this year. And that's really helping a lot of people whose EAD card has expired and who have not been able to get their new EAD card. So that's a good change that has happened this year. We also have the L visa dependents and the E visa dependents. And USCIS has brought about some new changes this year where the L1 visa dependents and E visa dependents, they don't have to apply for EAD cards anymore. Now they can work just incident to status. So that's a major change that is hugely impacting L visa dependents. So the L1 and the L1A and the L1B visa dependents to work in US without having to go through the EAD process. And it has made working in the US a lot more easier for the spouses of L visa employees in the country. And the H4 EAD folks. So for the H4 EAD, USCIS made some major changes this year. And now the H4 EAD folks, the applicants whose EAD card has expired, but who have applied for their EAD extension can now work even after their EAD card expiration, as long as their I-94 is valid. So that's another important change for H4 EAD people that USCIS has implemented this year. So that's also a very positive change that happened this year. And a more recent change that happened this month is to do with the premium processing for EB1. So USCIS is phasing in the availability of premium processing for EB1 I-140s. And what that means is for somebody who's looking to get a green card through the EB1C, the managerial green card process. So now they will be able to upgrade their cases. And that's another very positive change that has happened this year. And USCIS also recently released their processing goals for their applications, for their pending applications. And looking at the processing goals, they're clearly trying to speed up adjudication of many applications. And that's also a very positive change that has happened this year.
Yes. Thank you for the updates, Mr. Chan. Mr. Chan, let us get on to our topic today. So, we today decided to talk about deportation issues and committing criminal crimes act or acts when they are on a visa in USA. So, Mr. Chan, what exactly is deportation, and can you please explain or just give a basic introduction about our topic today?
Sure. So deportation is something that every immigrant dreads. So deportation means somebody is being thrown out of US. While they're in US, they're being forcibly thrown out of US for some reason. So deportation occurs when the federal government in US orders that somebody who's a non-citizen of United States, for example, somebody on a tourist visa, somebody on or a H-1B visa, or even a green card holder. So, if the federal government orders such a person to be removed from United States, that act is called as deportation. And deportation can happen for a number of reasons, but this typically happens if the person on a visa or a green card holder they do something to violate their status or violate some immigration laws or commits some serious criminal offenses. So when something like this happens, they get deported, and in legal terms, deportation is commonly known as removal. They don't call it deportation anymore; they call it removal, and removal means getting removed from US to their home country.
Yes. So, Mr. Chand, why does this happen, and also what kind of criminal acts can one do in order to get, will they get deportation?
So, in general, when somebody is in US on either a visa or as a green card holder, so one of the last things somebody wants to do is commit a crime. But if somebody on a either a visa, which is non-immigrant visa, such as a tourist visa, H-1B visa, B1, B2, or any of these kind of non-immigrant visas, or a green card, if they commit a felony, then they will get deported. So felony is something that always gets somebody deported. And immigration officials may also deport somebody even for a non-felony conviction. And depending on the type of offense, depending on the specific facts surrounding one's case, somebody could get deported. In general, the convictions for what are known as involving crimes involving moral turpitude. So that moral turpitude is an important keyword. So any of the crimes involving moral turpitude or those that can be labeled as aggravated felonies. These are the kind of crimes that one could cause somebody to be deported. So any of crimes involving moral turpitude or anything that has any kind of a criminal act that has very harsh consequences. So these typically will always get somebody deported. And a non-citizen who commits an aggravated felony, they are probably also ineligible for relief from deportation. And not only ineligible for relief, they're probably also barred from entering into US in the future. So aggravated felony is something that is, something that everybody should stay away from. Aggravated felony means they're not only getting thrown out of US, they also probably will never be able to enter US in the future.
Yes. Mr. Chan, can you please explain in detail about what exactly is aggravated felony in the deportation context?
So it was enacted a long time back in 1980s, and initially aggravated felony was limited to serious crimes. So aggravated felony is for something such as a murder or a federal drug trafficking or illegal trafficking of firearms. So initially it was meant for those kind of very serious offenses. However, a lot of offenses got added to that list ever since it was initially enacted in 1980s, sometime in 1980s. Now things as simple battery. So simple battery is somebody going and trying to hit somebody, filing a fraudulent tax return, failure to appear in court. So all of those also got added in. And from an immigration deportation context, these are all crimes that would get somebody deported.
Yeah. So, Mr. Chan, what exactly is crimes of moral turpitude, and how does this impact on people who with visa holders or green card holders?
So crimes of moral turpitude, this is a term that like everybody that's immigrant in US should know. And the reason being, one should stay away from crimes of moral turpitude. One should never commit a crime that could be stated as a crime of moral turpitude. Crime of moral turpitude simply refers to those acts that are determined by a court to violate the accepted moral standards of the community. So, as a community, we have certain moral standards. Anything that deviates from that path and the court determines, yes, it is against the moral standards and has a penalty, are known as crimes of moral turpitude. And a lot depends on the facts, a lot depends on the kind of conviction. So, there is not a hard and fast rule on what exactly is a crime of moral turpitude. But in general, uh, there are certain things that are usually always crimes of moral turpitude. And simple examples are things such as aggravated battery, aggravated assault, or some kind of a violence that caused bodily harm, and sometimes theft, sometimes spousal abuse, sometimes child abuse, rape. Is always a crime of moral turpitude. Child abuse is always a crime of moral turpitude. Animal fighting, driving under the influence of drugs. So a lot of these crimes come under crimes of moral turpitude. Anything the society loathes and society uh, feels very bad about the crime, as we as a society, typically you can consider that as a crime of moral turpitude. Anything that uh, the community, the society is turned off by that act, you can call that a crime of moral turpitude. So, crime of moral turpitude is a big problem in the immigration context. Anytime anybody is convicted, not just allegation is not enough. Anytime anybody is convicted in the court of one of these crimes, it's a serious problem to their immigration status, and more than likely they will be deported out of US.
Yes. Mr. Chan, are there any non-criminal acts, or like are there any non-criminal issues that can cause deportation for the visa holders?
Me looking at most of my clients who are Indian nationals, the criminal aspects are almost negligible because it is very rare that I see somebody with a criminal issue. So a lot of people assume that it is only the criminal acts that can cause deportation. But there are many issues that one has to be aware, because even non-criminal issues can also lead to deportation. And there are several reasons for US immigration authorities to deport an immigrant, which is basically sending back the person back to their home country because of some issue. And even a green card holder could be deported for a non-criminal issue. So what are these issues? The most common issue is failure to obey the terms of a visa. So what that means is anybody that's in US as a non-immigrant, for example, a tourist visa, a student visa, H1B, L1B, every visa will have certain terms that one has to follow to maintain status. For example, student, they're supposed to go and attend college. They're supposed to attend their classes. That's very important. If they don't attend their classes, they are failing classes. They're not taking their classes. They're violating their status. For example, B1, B2 visa. So on B1, B2, you're supposed to come as a tourist, visit the country, and go back once you're done with your task. You cannot really work in the country and start earning money and take up a job on a tourist visa. If you're doing that, you're violating your status. So violating the terms of the visa under which you're admitted to the country. If you violate the status, one could get deported. So that's very, very important to understand and make sure what is expected out of your visa. What are you supposed to do as a part to maintain status in your visa? It's very important, and one should always ensure that they follow the terms of their visa. Very important. Next thing that is very, very easy to forget is change of address. There is a very important rule in United States that anytime that somebody is in the country as a visa holder or even a green card holder, they are supposed to notify USCIS anytime they change their address. If somebody buys a house and moves to a new house, or relocate to another city, within 10 days, they're supposed to notify USCIS. If they don't notify, they could be deported back. In general, this is not really implemented by USCIS, but on paper there is a rule that says if you don't notify USCIS within 10 days of an address change, one could be deported. So it is very, very important that one follow the rules. And what that means is anytime you change your address, go to USCIS website. There is a form called AR11 that can be filed online. File that form online. Notify USCIS about your current address. At every point of time, USCIS should be notified of where your residence is. It is very important. And 10 days is the maximum leeway one gets. After 10 days, you are in non-compliance of the rule. So very important. It's a very simple thing to follow. Just notify USCIS by filing the form AR11. That's one thing. Another important thing is relying on public assistance. One, as an immigrant and as a non-immigrant, one cannot become a public charge. And what that means is if there is a government assistance program, a government welfare program, the government welfare program for most part are for US citizens. So one should not take advantage of a government welfare program. And if in doubt whether taking up on government's welfare program, whether it's a public charge, always consult an attorney. But the general rule is you should not become a public charge. You should not take public assistance. Any government welfare program, don't use it unless it is very clear that it does not count as a public charge. If in doubt, talk to an attorney. So that is also very, very important. And then the green card holders. So the green card holders also have to ensure a very important thing. They do maintain residence in US, and they're supposed to be residing in US, not maintain permanent residence in India, for example. So that's also another important thing. They can travel. They can travel anywhere they want in the world. The only thing is they're supposed to maintain permanent residence in US. So in general, so there are various non-criminal aspects that could lead to deportation, and it is highly important that one look at all these issues and make sure that they follow the law. And by doing so, they don't have to worry about deportation.
Yes. So, Mr. Chand, let's just say that somebody has got a speeding ticket, or like any minute instance or are filed on them. Must they worry about getting deported? And if there are, what are some minute or small incidents that the government or the US government can, set aside, and the people should not worry as much as they will be worrying?
Sure. So the speeding tickets. So technically, the speeding tickets are citations. They are citations given by a police officer. Citations are important. Anytime somebody gets a citation, make sure you keep record of it, because the day one applies for their citizenship, there is a question on the form that says, "Do you have any citations?" Every citation should be disclosed, even if it is a small citation. One has to disclose their citations. However, if it's a traffic citation, a traffic violation, more than likely one will not have any issue in general, unless somebody is a habitual person that gets tickets. If somebody gets, say, like 10, 15 tickets in a year, they're habitual violators of law, various traffic laws, then there might be a problem. But in general, minor traffic tickets, minor traffic violations, one might not have to worry so much. And some issues that I've seen in the past, some issues regarding theft or some issues. I've seen issues where people ran into issues with the law for various reasons. They got involved in some theft, and they got caught. They got convicted. So for those people, there is something called a petty offense exception. So in US, if somebody commits a minor offense, a petty offense, and it's a one-time offense, and after that they have not violated their status, and they have not had anything bad on the history except one simple offense, a petty offense, they could qualify for something called a petty offense exception. And again, this is something that they might have to discuss with an attorney, because anytime, even if it's a simple offense, traffic offenses are something that one does not have to worry about. If it's a simple traffic violation that has a fine less than $500, so anything that's a traffic violation less than $500, I would not worry about it. Now, more than likely, they will never have an issue about it. But anything that is more than that, even if it's a misdemeanor, simple theft, or I've seen issues where there was domestic disturbance and the spouse complained about the other spouse, and somebody had it in the criminal record. So these things, these are bad on the record, but one does not have to worry about deportation based on the severity of the crime, because there is something called a petty offense exception. So anytime somebody has a criminal history, even if it is minor, make sure you discuss it with somebody that has immigration law knowledge and also criminal law knowledge, because all immigration attorneys do not practice deportation and removal defense and those kind of things. For example, in our law firm, I primarily practice employment based law. I am not an expert in the criminal side of the law, so I typically refer people to other attorneys who deal with criminal offenses. So in general, if somebody runs into an issue with the law, they have some criminal record, make sure you discuss it with an attorney that deals with both criminal offenses and also immigration law. So there are attorneys that practice uh, immigration law from a criminal law standpoint. So anytime one has a criminal history, definitely check with attorneys. But do understand that there is a petty offense exception, and what that basically means is that if it's a simple offense, it's a one-time offense, you might qualify for some waivers or for some exceptions, where USCIS might forgive that offense because it's a small offense, it's a one-time offense.
Yes. So, Mr. Chand, will a drug crime charge affect one's status in USA?
Yes. So drug charges are something that are very, very serious in US, and one has to be very, very cautious. And again, there are two kinds of drug offenses. One, one has been convicted because they have drugs on them. They have, however, it is for personal consumption. So that is one area of convictions that I see. And then there are other drug convictions for possessing the drugs in such large quantities, where the conviction is for trying to sell it to somebody else. So the drug offenses are very, very severe offenses, and this could lead to deportation. A common concern that many people raise nowadays is to do with marijuana. Consuming marijuana for personal reasons is legal in many states in US. For example, Colorado, for example, California. Many states, many states right now in US make it legal for US citizens. So as a US citizen, you can go to the stores, you can just buy marijuana, and you can just consume it for your personal needs, for recreational needs. It is completely legal for US citizens. However, if you are an immigrant or a non-immigrant, according to the federal law, it is still an offense. So even if it is legal as per the state law to consume a recreational drug for personal use, make sure if you're an immigrant or non-immigrant, you don't do drugs, you don't consume marijuana, even if it is legal in your state. So it is a very, very important thing. So drug offenses, the waivers are very, very, I mean, if somebody gets convicted in a drug offense, more than likely somebody might be deported. So one should definitely stay away from drugs. Drug offenses have very serious consequences from a federal law standpoint, from an immigration law standpoint.
Yes. So, Mr. Chand, can you generally explain about how will a US government deport someone? Like, do they have to go to courts? Are there any issues, and how exactly is this process?
This process is called as a removal process in US. So removal process is where the US government starts the process uh, of removing somebody from United States. And because US, we have, I mean, it's a democratic nation with proper laws. The way the laws are designed are to give proper due process to everybody in the country. So even if somebody needs to be deported, they're not just like put in jail and deported. A proper process is followed in US, and so that proper process starts off with Department of Homeland Security. So Department of Homeland Security is the body that is responsible for starting a removal proceeding. and they start this removal proceeding through its division called ICE. So this ICE is also known as Immigration and Customs Enforcement Division, and through this department, through this division, they start this process. And what ICE typically does is they give something called notice NTA, a notice to appear to whoever they need to remove, and so they serve this notice to appear. And what this basically says is you should come and appear before an immigration judge. That's pretty much what the notice to appear says. And it will tell this notice to appear. This notice will state the nature of the proceeding, will also talk about the alleged grounds for removal, because we want to give the due process. We want to tell somebody why they are being removed. So it will talk about the alleged grounds for removal. It also talks about the person's right to hire an attorney. Of course, it is at their personal expense, but it at least talks about that right. It tells somebody that you are supposed to come for the proceeding, but you also have the right to hire an attorney. And it also talks about the consequences of failing to appear at this hearing. And removal hearings, they are held before an immigration judge. So everybody gets their shot in front of a judge, and they're able to come in front of the judge, explain their situation. And the immigration judges, so they operate under something called EOIR. And this EOIR, it is basically the Executive Office of Immigration Review. So this is the body under which the immigration judges operate. And the immigration judge will be the one that will determine whether the non-citizens' actions or maybe their lack of immigration status or whatever is their situation. They are the ones that will decide if they are removable, or whether they can probably grant them any relief. The relief is basically whether they can let them stay back in the country, whether they qualify for any discretionary relief. That is what the judge would decide. And the way the court works is, initially there is something called the first hearing, which is also called as the master calendar. And everybody should attend master calendar. They don't have a choice. And it is very, very important that they go to this first hearing. They should attend it in person. And one cannot afford to miss the master calendar hearing. If at all they miss the master calendar hearing, the consequences are very, very severe. They will never be able to return to US for the next 10 years. So it is very important that somebody attends the hearing. So this is called the first hearing, master calendar hearing. And the next step is called the merits hearing. So the merits hearing is where somebody typically can go with a lawyer. The lawyer will argue on the law or whatever case they have, and will try to argue for some relief. So if the relief is granted, they get to stay back in the country. So the merit hearings are done, and then that is when the immigration judge will issue their decision.
Yes. Thank you, Mr. Chan, for joining on to our show today. We had an amazing show. We did cover so many different topics. Thank you for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.